If you're a business owner trying to keep up, you're probably wondering what the change in the overtime rules means for your company. The U.S. Department of Labor has officially rescinded the 2024 overtime expansion rule, which would have significantly increased the salary threshold for employees who are exempt from overtime. I'm Alex Rubin of Rubin Employment Law. So now the federal thresholds have officially gone back to their 2019 levels, $684 per week or $35,568 per year, and $107,432 per year for highly compensated employees. Note that some states like New York have higher thresholds. For some employers, this may feel like a relief. But here's the important thing you need to understand. This does not mean overtime compliance suddenly becomes easy. Just to be clear, this video is for informational purposes only. It is not legal advice, and watching it does not create an attorney-client relationship. For legal guidance, please speak with an employment attorney in your state. One of the biggest mistakes I see employers make is assuming that if they pay someone a salary, that employee is automatically exempt from overtime. That's not how the law works. Salary level matters, yes, but the employee also has to satisfy what is called the duties test. In other words, what the employee actually does every day is critically important. And this is where businesses can run into trouble without realizing it. You may have someone with a manager title who spends most of the day doing the same work as hourly employees. You may have coordinators or administrators who are salaried, but who do not exercise the level of independent judgment required for an exemption. You may have working supervisors who are primarily performing operational tasks instead of management functions. Titles alone are not enough. Wage and hour claims remain one of the most active areas of employment litigation because these cases can become very expensive very quickly. Now, another issue employers are dealing with is this. During the last year, many businesses already made changes in anticipation of the higher salary thresholds. Some raised salaries, some reclassified employees from exempt to non-exempt from overtime. Some implemented new timekeeping systems. So now the question becomes, do we reverse those decisions? Maybe, maybe not. That's because compensation or classification changes may create employee morale issues, consistency issues, retention concerns, and legal considerations. This is why I always tell employers that wage and hour compliance should not be treated like a one-time payroll adjustment. It needs to be part of a larger compliance review. Now is a good time to look at your classifications, your job descriptions, actual day-to-day duties, remote work expectations, after-hours emails and texting, timekeeping practices, and your state law requirements, because state laws are sometimes stricter than federal law. The rules may have shifted again, but the risks did not disappear. For employers, the safest approach is not guessing. It's making sure your classifications and practices actually match the realities of your workplace. If you have questions about whether or not your company is handling overtime properly, call us at 973-787-8442. Email us at legaladmin@alexrubinlaw.com or visit us at alexrubinlaw.com/overtime-rule-2026.